Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. After Mr. Koberger pled guilty to the 5 serious first-degree felonies he was about to stand trial on, Judge Stephen J. Hippler stated words to the effect, "Now, I recognize the plea agreement includes a waiver of the right to appeal, but as the parties probably know, the U.S. Supreme Court in Garza versus Idaho has indicated the fact that a defendant waives the right to appeal doesn't mean that they don't have the right to appeal. And so it may affect the outcome of that appeal, and it may affect the underlying case and the plea agreement." On June 18th, 2026, the Supreme Court of the United States revisited Garza versus Idaho, the 2019 Supreme Court ruling in the matter styled as Hunter versus United States, and ruled 8-1 decision that the miscarriage of justice standard is what now applies unilaterally across the country for defendants who sign away appellate rights, as Mr. Koberger did when he entered into the plea agreement with the government. What would he need to show if he decides to appeal? Now, caution, there is no indication as of this time that Mr. Koberger is going to appeal his sentence, but for discussion purposes only, is bringing action under the Idaho statute, section 194901. This is a remedy for people who have been convicted to be able to challenge their sentences. The first grounds that the conviction or the sentence was in violation of the Constitution of the United States. Now, in a post-Hunter world, the person would, of course, need to show a constitutional provision was violated here. But then again, recall that there is the signing away of the appellate rights, so would have to show a miscarriage of justice, a constitutional guarantee that has been spoken about many, many times, raised many times in various pleadings in Idaho versus Koberger. It is the Sixth Amendment privilege to counsel. And what has been challenged over the years when defendants attempt to get their sentences set aside is a violation of the Sixth Amendment, ineffective assistance of counsel. There is a case that would govern in any such assertion. It is called Strickland versus Washington, case number 466 U.S. 668. This is a 1984 SCOTUS case. And what this case states is that the respondent pled guilty in a Florida trial court to an indictment that included 3 capital unaliving charges. The respondent told the trial judge that although he had committed a string of burglaries, he had no significant prior criminal record, and that at the time of his criminal spree, he was under extreme stress caused by his inability to support his family. In preparing for the sentencing hearing, defense counsel spoke with respondent about his background, but did not seek out character witnesses or request a psychiatric examination. Counsel's decision not to present evidence concerning respondent's character and emotional state reflected his judgment that it was advisable to rely on his statements to the court for evidence as to such matters, thus preventing the state from cross-examining respondent and from presenting psychiatric evidence of its own. Counsel did not request a pre-sentence report because it would have included respondent's criminal history and thereby would have undermined the claim of no significant prior criminal record. Finding numerous aggravating circumstances and no mitigating circumstances, the trial judge sentenced respondent to the ultimate capital penalty on each of the unaliving counts. Florida Supreme Court affirmed. Respondent then sought relief in state court on several respects, including the failure to request a psychiatric report, to investigate and present character witnesses, and to seek a pre-sentence report. Trial court denied relief. Florida Supreme Court affirmed. Respondent then filed a habeas corpus petition in federal district court, advancing numerous grounds for relief, including the claim of ineffective assistance of counsel. After an evidentiary hearing, went to the U.S. Supreme Court. What the Supreme Court found, here's the standard now for claiming ineffective assistance of counsel. 1, the Sixth Amendment right to counsel is the right to the effective assistance of counsel. And the benchmark for judging any claim of ineffective assistance of counsel must be whether counsel's conduct was so undermined the proper functioning of the adversarial process that the trial cannot be relied on as having produced a just result. Same result applies to a capital sentencing proceeding, such as the one provided for by Florida law, that is sufficiently like a trial in its adversarial format, and in the existence of standards for decisions that counsel's role in the proceeding is comparable to counsel's role at trial. 2, a convicted defendant's claim that counsel's assistant was so defective as to require reversal of a conviction or sentence, setting aside of a sentence, requires that the defendant show, first, that counsel's performance was deficient, and second, that the deficient performance prejudiced the defense so as to deprive the defendant of a fair trial. So there you see the legal standard. Number 1, have to raise the Sixth Amendment if the claim for ineffective assistance of counsel is the grounds to seek a new trial, to seek to set aside a conviction, and has to show that counsel's performance was so defective and that the deficient performance prejudiced the defense so as to deprive the defendant of a fair trial. Now, in discussing what the application of the Strickland standard could possibly mean to Mr. Kohberger, could there be, in this hypothetical situation where the Sixth Amendment is raised, ineffective assistance of counsel, leading to a miscarriage of justice, would there be grounds for him to say, we went to sentencing, there was no pre-sentencing measures that were taken to try to mitigate this sentence. There were no psychiatrists that were called in to make sure that he was in the right frame of mind, that this was a willing and a voluntary plea, waiver of constitutional rights. We have encouraged you to look at Mr. Kohberger's June 29th, 2025 waiver of constitutional rights forms. It appears he may, and again, caution, may have been confused at certain parts. He crossed things out. Things seemed to contradict each other. He said he had been diagnosed with a mental condition, but there was no psychologist that assisted, apparently, in filling out that form. If they did, they certainly didn't sign it, and Judge Hippler didn't ask about it at sentencing. Now, if Mr. Kohberger decides to move under the statute to try to get his conviction set aside, remember, he signed a waiver of appellate rights, so he's got the additional hurdle of showing that there was a miscarriage of justice present.